If you've been injured in an auto accident, what you need to know about the insurance claims settlement process is that most adjusters are super skeptical, and so are many juries. And so in today's video, I'm going to be talking about 3 things that can happen in your medical record that can really screw up your case and prevent you from collecting as much money at the end of the case as you thought the case was worth. The number one thing that you can do to screw up your case is to give your doctor an inaccurate medical history. So here's what this looks like. In a rear end crash, if you have a neck or a back problem and you go to a new doctor, or even if you go to your regular doctor and you tell them, I've never had any problems with my neck or my back before in my life, and that's not true, right? What we've seen in some cases is you have somebody who's got maybe a prior surgical history, or they've been in and out of physical therapy, or they had an MRI that showed a herniation in the back, and they never tell the new doctor about it. You have to tell your doctor when you had prior injuries so that the doctor can accurately assess, is the problem that you're having today, is it from the car crash or is it from your prior medical history? And it's important, even if it is from the car crash and it's not from your prior medical history, that your doctor be told about that prior medical history so that they can distinguish it, right? If you had a surgery 10 years ago, but you haven't seen a doctor in the last 8, we need to at least tell the doctor about your prior surgery so that it goes into the medical records so that the doctor can say, had a surgery 10 years ago, hasn't seen a doctor in the last 8, okay? Because otherwise, when the x-ray mentions that you have hardware in your back, but your doctor's notes don't say anything about it because you didn't tell them, then that starts to raise some eyebrows at the insurance company. The other thing that I've seen some doctors' offices do that they think is helpful but really is not is create a new file for your new case. So I've had cases, unfortunately, where I had somebody who was seeing a chiropractor for a number of years, but after the crash, the doctor created a brand new file for them, so they had no history in their neck or their back. And I didn't even find out that they'd seen this chiropractor beforehand until we were sitting in the deposition of the doctor, and the defense said, I subpoenaed your record, you never sent it to me, can I see it now? And the doctor said, which file do you want? Do you want both of the files? And at that point I knew that our case was torpedoed because my client had seen the doctor only 2 weeks before this crash for similar complaints. And had I known about that, we could have tailored our negotiation strategy and tailored our case strategy to accommodate for it. But if I don't know about it, I can't solve it. And so hiding your past medical history, or even worse, having your doctor hide the past medical history, that's a big no-no in an auto accident case. The second thing that's along the same lines is not embellishing your injury after a crash, okay? So I've seen cases where there's scratches or there's not a whole lot of damage to the back of the car, and yet when the person goes to the emergency room or they go to the chiropractor, they're saying it's 9 out of 10, it's 10 out of 10 pain. And that may be true. But what doesn't happen in cases is that it's 10 out of 10, 10 out of 10, 10 out of 10, and then the week of discharge it's down to 1 out of 10, right? Usually we see either a nice glide down in the pain, or sometimes it moves around a little bit. But telling your doctor through the course of your medical care that your pain is off the charts when it is not is a bad thing for the case. More cases have been hurt by that than have been helped. So it's important that you give your doctor an accurate picture of what's really going on with your body. Now, if the pain is 10 out of 10, 100%, tell your doctor that. But don't tell them it's 10 out of 10 when it's really a 5 because you think it's going to make the case better. Third thing that we see really infrequently, but it is a problem, so I'll address it here, is doctor shopping. So going to a physical therapist and a chiropractor and an acupuncturist and a massage therapist. Don't do that, right? Go to 1, maybe 2, but make sure that they each know about each other and reference each other in their notes. Because what happens is the insurance company gets this huge bill because you have 4 medical doctors or 4 treating providers treating you, and they say, well, we're going to pay for 1 of them, right? At least if the doctors know about each other and they reference each other in their notes, then that allows us to say to a judge or to a jury, no, these doctors knew about it. They're the medical professionals, not the defense lawyer, not the defense adjuster. If they knew about it and they were okay and they thought it was reasonable, then judge, you should accept this as reasonable too. But if we are seeing a bunch of different doctors, and sometimes I've seen clients who treat with doctors and can't get the case settled and then come and hire us, and they're treating with 2 chiropractors at the same time. It's the same specialist, right? That's a problem. We can't do that and expect the insurance company to pay for it without a really good explanation. And so don't take your case to a bunch of different doctors. Take it to one quarterback and allow that quarterback to marshal out your care and tell you what you should do. I hope those 3 things to avoid are helpful to you. I've got a bunch of other videos on this channel about things to do and things to avoid after an auto accident. And remember, if you've been in a crash in Virginia and you need some help, give my firm a call.